Jon Feere, now our legal policy analyst.
Thank you, Mark. Thank you, Jessica. Thank you, David. Despite all the reasons for not moving forward with a comprehensive bill just listed by Jessica, we may nevertheless see an effort at some sort of a large-scale bill before President Obama's second term is up, if not this year, according to the New York Times article from yesterday. There are at least three reasons why a comprehensive bill, in and of itself, is possibly problematic. First, the negotiated terms, as written on paper, often operate differently in practice. Second, advocates of high immigration are disingenuous in their support for comprehensive bills. And third, the enforcement portion of comprehensive bills never seems to materialize, and presidents always seem to limit the scope of enforcement provisions on their own. As to the first point, the terms of immigration legalization programs are often presented as one thing, but in practice are quite different. The most recent example to really highlight what we should expect in a future immigration bill is President Obama's Deferred Action program, which we've heard a little bit about. There are a number of myths, if you will, repeated by the Obama administration and the media about the components of the Deferred Action program. The goal of high immigration advocates oftentimes is to paint a picture that voters can embrace, even if that picture is somewhat inaccurate. A few examples highlight this phenomenon. First, there's always a problem with the numbers. The public wants to know, how many illegal immigrants are we talking about legalizing? Amnesty advocates regularly lowball the number, understanding that the public is weary of massive immigration programs. As soon as President Obama announced his Deferred Action program, his staffers claimed that it would benefit only 800,000 people in the country illegally. Soon after that, we started fielding phone calls from a number of journalists asking us where that number had come from. We had no idea. Our director of research decided to run the numbers himself based on the terms of deferred action, and he found that in reality the number was somewhere around 1.5 million. The Pew Hispanic Center put it at 1.7 million. It turns out that the original estimate being sold to the public was maybe half of what the actual number would be. But these estimates assume no fraud. Again, as was mentioned, the number of qualified applicants is not the same as the number of people who will actually benefit under an amnesty. And as has been pointed out, amnesties are notorious for fraud. In 1989, a few years after IRCA, the Brookings Institution's Roberto Suro accurately pointed out that the amnesty was one of the most extensive immigration frauds ever perpetrated against the United States government. That's a direct quote. And he noted that, quote, federal officials and immigration experts placed the number of fraudulent applications at somewhere between 250,000 and 650,000, end quote. In fact, today we know the number might have been even larger. It is more than likely that the Deferred Action program and future immigration bills will benefit thousands of people who are technically ineligible. Another claim that we see with comprehensive bills and with Deferred Action program is that they are written to not benefit those who have a criminal history. There will be a background check, it's claimed. It sounds good. In reality, under DACA, applicants can have extensive criminal records, provided they have not been convicted of a felony, a significant misdemeanor, or 3 or other misdemeanors. This means that an illegal alien with 2 misdemeanors would not be barred under the DACA program. These misdemeanors include things like petty theft, possession of drug paraphernalia, public intoxication, fleeing from an officer, disorderly conduct, vandalism, indecent exposure, prostitution, trespass. But that's only half the story. The timing of the misdemeanors is significant as well, in that multiple misdemeanors may only count as one strike against the applicant. As USCIS explains in its DACA guidelines, if an applicant is ineligible if he has 3 or more misdemeanors, quote, not occurring on the same date and not arising out of the same act, end quote. In other words, an illegal immigrant who commits a handful of misdemeanors during one incident will see those crimes counted as one misdemeanor for purposes of DACA. An alien could commit additional series of misdemeanors at a later date, provided they all happened at one event. Those would again only be counted as a second misdemeanor. He would still qualify for deferred action. Amnesty advocates also point out that illegal immigrants are deserving of legalization because they're already here working. Of course, illegal immigrants who hold jobs have acquired their positions through deception, through fraud, and are often engaged in identity theft, Social Security fraud, I-9 form fraud, just to name a few examples. And while this lawlessness creates real victims, it's unlikely to turn up in a background check because most illegal immigrants have not been prosecuted for these crimes as a result of the Obama administration's existing policy of giving so-called low-level offenders a pass. Now, there are many other features of amnesty bills and legalization bills that operate differently than one would expect. For example, the Learn English requirement was never actually written in a way so as to actually require illegal immigrants to learn English. Attending a few English courses was sufficient under IRCA. The requirement that deferred action applicants must prove they lived in the United States for 5 continuous years isn't what it seems. Under immigration law, an alien seeking naturalization must also prove 5 years of continuous residency, but that can still be met if the alien has been absent for the country up to 6 months. Even multiple 6-month absences in the course of 5 years is not a problem. The point is that the negotiated parameters of immigration bills are usually quite different in practice. The second point, advocates of high immigration are disingenuous in their support for comprehensive bills. History shows us that for the most part, they're only after the legalization portion and will do everything in their power to undermine the enforcement provisions as soon as the bill becomes law. Here are 2 reports authored only a few years after IRCA was passed, one by La Raza and one by the ACLU. The law had only started to roll out, and yet both the ACLU and La Raza were calling for an end to workplace enforcement, and that was the crux of the enforcement provisions of IRCA. What makes this even more interesting is that the La Raza report was authored by Cecilia Munoz, who now operates out of the White House as President Obama's chief immigration advisor. In this report, she wrote, quote, "Congress should repeal employer sanctions," end quote. She even argued that Congress has a, quote, "moral obligation to repeal employer sanctions," end quote. And one of the reasons that Munoz claimed that employer sanctions should be eliminated was because she felt the sanctions were uneven and inconsistent. And I make the same argument today. Of course, things could have been made more consistent by making E-Verify a standard part of the hiring process, just like filling out an I-9 form is. This would be effective, it would be consistent, but La Raza and the White House do not appear interested. And that's because honest immigration enforcement is really not what they want. Remember, these same groups, including the White House, sued Arizona all the way to the Supreme Court to stop the idea of states mandating use of E-Verify. Interestingly, in this report, Munoz also seems to point out that mass legalization programs really don't work. She wrote, quote, "NCLR estimates that the size of the undocumented population today," this was in 1989, 1990, "perhaps 3 to 4 million persons equals that of the early 1980s when the debate over IRCA took place. In the wake of this one-time only program, the nation appears to be left with at least as many undocumented people as when it first considered these proposals," end quote. In other words, amnesty didn't work then to reduce illegal immigration, and it won't work today unless we see robust immigration enforcement across the board. These reports tell us 2 things. First, the goal of these advocates was not to amend IRCA, not to improve sanctions, not to make them more efficient. No, the goal was to end workplace enforcement altogether, and they continue to advance that cause. The second point is that advocates will call for another amnesty, just as they did in this report only a few years after IRCA, when it becomes clear that amnesty doesn't work for reducing illegal immigration. In fact, makes it worse. The third point is that the enforcement provisions of comprehensive bills never seem to materialize. Presidents tend to limit the scope of enforcement provisions, and President Obama has given plenty of reasons to believe he will not vigorously enforce immigration provisions in a comprehensive bill. The question that many people are contemplating is whether President Obama can be trusted to honor a grand bargain on immigration. Because if he cannot, if the enforcement provisions will not be vigorously enforced, then we'll simply end up in 10 years or sooner, exactly where we are today, with millions more illegal immigrants in the country. There will be calls for another amnesty, and the press club will be fielding another panel discussion just like this. On the other side, in fact, I should also point out that the 1986 amnesty, IRCA, was not the last amnesty we had, as Jessica alluded to. There have been at least 6 amnesties since then. They have never reduced illegal immigration. On the other side, we've had enforcement-related bills. The big one was in 1996, the Illegal Immigration Reform and Immigrant Responsibility Act. Even though last week the director of the Migration Policy Institute referred to the 1996 law as a scorched earth policy, The reality is that the White House administrations have narrowly interpreted the scope and the intention of these enforcement tools provided in the 1996 Act. And a couple of examples are vivid and hint at what we should expect in future bills containing enforcement provisions. First, expedited removal is a program that came out of the 96 law, which allows illegal aliens without an asylum claim to be quickly returned home without a lengthy trial or the involvement of immigration judges. As written by Congress, the policy applies to nearly any illegal alien apprehended anywhere in the United States, provided they have not been continuously present in the United States for longer than 2 years. However, successive administrations have not implemented expedited removal to the extent the law allows. And our other panelist, Congressman Lamar Smith, was one of the ones who co-authored this bill. The Clinton administration implemented expedited removal only at a few ports of entry, while the Bush administration decided not to use the expedited removal process for Mexican or Canadian aliens, with rare exceptions. Today, expedited removal is only being used for aliens apprehended within 100 miles of the borders, and only if the alien is apprehended within 14 days of entry. Rather than expand immigration enforcement, administrative changes have narrowed application of an enforcement program authored by Congress that could save the country millions of dollars while discouraging illegal immigration. A second example to come out of the 1996 immigration law is the 287G program, which allows state and local law enforcement to assist federal immigration authorities in carrying out immigration enforcement. The program has identified hundreds of thousands of illegal immigrants for removal with the help of over 1,300 state and local officials in 25 states. As soon as President Obama took office, the ACLU came out with a report calling for an end to the 287G program. Now, the report is full of hyperbole, like comparing state and local enforcement with the internment of the Japanese during World War II. I'm not making this up. And it was full of inaccuracies. They claimed that 287G was written for the purpose of removing only aliens convicted of violent crimes. But no such distinction is in the statute. But it didn't matter. The Obama administration took the ACLU report to heart and immediately started scaling back immigration enforcement. Through administrative action, the Obama administration made violent offenses such as murder, manslaughter, rape, robbery, and kidnapping virtual prerequisites for immigration for deportation. In other words, people now have to be seriously injured before immigration laws are taken seriously. That's not a benefit to public safety, and that was never the intent of Congress. But it gets worse. Early last year, the Obama administration decided to terminate 7 task force agreements that ICE had with Arizona, as Jessica has written about. Apparently, the immigration task forces were too successful. Then, right before Christmas a few weeks ago, President Obama thought no one was paying attention, so he terminated 32 task force agreements. This is unfortunate because the program has taken many dangerous people off the streets. If we look at the past 4 years under the Obama administration, nearly every effort the president has made on immigration has been designed to weaken immigration enforcement and to change things administratively in a way that benefits those who are here illegally. His record makes it difficult for Americans who support the rule of law to trust the administration with comprehensive bills. We're getting short on time. I will leave it there.